Estate planning attorney Jeff Fouts here. As we all know, life doesn't slow down, life doesn't really stop for anything, and eventually you're going to die. Okay, and then there's going to be, probably, a death probate. People think, or under the mistaken belief that when they die, that their financial power of attorney person will continue to make decisions. That's not true. When you die, your financial power of attorney dies when you do. The instant you die, that document now has no legal effect. Well, what about the will? Well, people think that if you have a will, and your will, of course, names an executor or an executrix, if it's a lady, that your executor will be able to have authority to make decisions when you die, and that's not true. As a matter of fact, people really aren't always understanding of how that process works. And so when you die, you must do something in order to get your executor to have authority. And merely you dying doesn't do it. So yeah, you must die, yes, of course, but then something else must happen. And that something else is called the probate process. And so the probate process is a process that goes back to Old England, Middle Ages. And it is a number of legal steps that someone is going to have to take. And so before your executor will have authority, what are those steps that have to be done? Well, first of all, someone has got to go to the courthouse and file a probate petition. And so that's the first job. Then they must put a notice in the newspaper. Then they must wait on creditors to respond. And your person that filed your probate must make sure that they selected the best kind of probate. There's different kinds. Because if they did not select the proper kind, then that means your creditors can still come after you and your estate, potentially years down the line, and it surprises people. So, okay, those are the first steps. Next step is you must obviously wait on the creditors to respond. Then you must send out a notice to your heirs, and that's not just the people getting stuff in the will. That's not all that means. It must send them to what's called your heirs at law. So then we must send that notice out to your heirs at law, and when we give them that notice, they must respond. Okay, and if they don't respond, if they just merely leave it sitting on their kitchen table, then the whole probate process locks down. Well, what if they don't like what's going on, and that document gives them a real easy way to just write down that they don't like what's going on, okay? And so, I don't like what's going on. And so, well, that stops the whole process as well, and that's not good. So then what? Well, so that is really the reason why there is so much litigation involved in estate planning. Probate. Because in probate, you're having to send them a notice saying, hey, if you don't like what's going on, you just let us know. And it's cheap, and they don't even have to hire an attorney. They just write in there, I don't like it, and now the process locks down. And so, not too good. It's not very good. So that's the reason there's so much litigation. But then you must put a inventory of all the assets in the court, and those assets, all that is public record. Anybody, anywhere can go into those court records and look up what it is that your wife is going to get after you die. And so it's all public record. And a lot of ladies don't like that. And then what happens is then the judge must review everything, and then after the judge reviews everything, then and only then he gives a piece of paper to your executor called letters testamentary, and it's only at that time that your executor has legal authority to take action. Not when you die, not when the probate's filed, but when the letters testamentary are issued. And that kind of takes some people by surprise, because probate is not fast. It takes some time. But anyway, if we could ever help you in the future, or maybe perhaps review your estate plan, just let us know. Thank you very much.